Well, this one took off for a while. It's considered a very healthy thing to do.
I'll be okay. You're right.
Did I tell you what David Mills said he did this?
Mr. Crane, good morning.
Good morning. May it please the court, Edward Crane on behalf of Quentin Williams. This case asks whether a prospective juror can still be considered fair and impartial if they express the viewpoint that the criminal justice system is unfair to young black men. Juror number 15 believed this to be true.
You didn't say unfair, right? Rigged, right?
Rigged, correct.
It's somewhat different, right?
It's somewhat different, but I think they're basically synonyms.
Can you get into what you raised in your brief and the amicus raise are issues of belief systems and appropriately that jurors don't come to the courthouse as blank slates. But are there some belief systems that are disqualifying from jury service?
I think there are certainly some belief systems that would be disqualified.
Okay, so here
from jury
we have a belief system where juror 15 says the system's rigged against African Americans, right?
Yes.
And your argument is that that's a legitimate belief system and that person should be qualified to serve as a juror. But if a juror said something differently as far as a belief system, like all Italian males commit crimes, right? That person doesn't serve.
Of course not.
All right, how does a judge figure out which belief systems are disqualifying and those that aren't disqualifying?
The question, really the question that the judge has to consider is, does the belief system suggest bias or a lack of impartiality? Is there a link between the belief system and some sort of bias? Clearly, if a prospective juror comes forward and says all Italian men commit crimes, there's a clear link between that person's belief system and a bias.
So that's what we're looking for. Is that so? Let me ask you. And you're a trial lawyer, correct?
No, I'm a appellate lawyer.
Okay, appellate lawyer. All right, put your trial lawyer shoes on. So you're representing a client, and it's a sexual assault case, and the prospective juror says, "I believe all," and there's the full block questions about rape and the like, and sexual assault. And the juror says, I think that the system's rigged against those that complain about sexual assault. I have a roommate who was raped in college, and that's what I think happened. Is that person a qualified juror or a disqualified juror?
I don't think that statement alone would disqualify that person from serving on the jury. I think in that instance, what the trial judge has to do, and really what the trial judge should have done here, is bring the juror forward and probe them further. I think the question would, the first question the trial judge needs to ask is, would that belief affect your ability to render, say, a guilty verdict in this case if it was supported by the evidence? Or would this belief system affect your ability to apply the law as instructed to the facts? Would this belief system affect your ability to listen to all the evidence? So I think that in that instance, not on its face, not just that statement alone, I think is disqualifying, but certainly if there was further probing, and there needs, because there is a suggestion there, like, okay, this could potentially be a bias. We need to dig a little deeper here. And I think that's the same thing that should have happened here.
Well, is that what happened here? Isn't that what the judge did here? And the judge basically said, can you put that aside? And she says no.
And I think that when she says she can't put that experience aside, I think the issue there is that the fact that she can't put it aside is, first there has to be established that the viewpoint that the criminal justice system is unfair to young black men actually suggests a bias, that there is some sort of suggestion of bias or lack of impartiality.
Well, but counsel, we're talking about two different things, aren't we? I mean, there's a systemic problem that's broad, that runs through many, many, many different kinds of cases and situations. And then there's one particular case with one particular defendant and one particular juror. And we have to apply the rules evenly in these individualized cases and recognize the individual case can't correct the systemic problem. Isn't that what was happening in this instance?
Yes, of course, this one case can't solve the systemic problems.
And to what extent do we defer to the trial judge who said, who was looking at the witness and listening, and he says, she struggled, she hesitated quite a bit. She really struggled with it. She said she'll try, and that seemed to influence his opinion very much, that she struggled so much to come to just a question of could she be fair?
I think of course, there's the general principle that we give deference to trial judges, but in this instance, I think a number of what are essentially his factual findings are not supported by the record and could be.
That's because the question's missing. I mean, I think you've already alluded to this. So somebody comes in, they think the criminal justice system is unfair to African Americans. That doesn't mean they can't be a juror. Somebody who's been raped as a child doesn't mean they can't be a juror in a child rape case. And so the judge is going through the questions, and then we miss the most important question, which is, are you going to be able to be a fair and impartial juror, bringing this life experience with you, as you should, into the jury room? And when she says, basically, I think so, the judge doesn't say, well, I think so. He sort of says, I think so's not enough. That's not true. You got to ask, well, do you have any reason to believe that you couldn't? Do you have any reason why you couldn't be fair and impartial? And you've already alluded to this. The problem here is that there's one missing question. You're conscious of any reason why you couldn't be fair and impartial, taking into account your belief system.
Yes.
And that's it. I mean, it's the missing question that's the problem.
Yes, I absolutely agree. And
Do you think, getting back to what you said earlier, that one of the problems is the judge asked the general question, is there anything that would interfere with, right? And she raises her hand, she comes up for a question, and the judge immediately starts inquiring about a bias. Is that part of the problem, that the judge hears belief system and then jumps to bias and labels it as a bias?
I think so. I think it's somewhat in how he labels it, but also in his head. I think it's clear that he believes it's a bias, and I think that he gets that. As soon as she comes up, he's speaking to it and referring to it as a bias. So clearly, in his head, he's already sort of made this decision that this is a bias.
Well, it's interesting because it's in an exchange with the clerk. On page 108 of the transcript, I believe that you might have answered a question affirmatively. He says to the juror, was that a hardship question? She said, and the clerk says no. The court says no. The clerk says it was unfair and impartial. Oh, the court says, being you, and then the clerk says, on bias. So it's the clerk who says, on bias. And then the judge says, you feel like you might have a bias in the case. And she says, yeah.
So isn't what are we talking about when we say bias? What's the definition that we're using here? I guess would be my first question. And then if you have a bias, does that mean you can't serve, or do you have to look more into that? Does a bias mean you're unqualified, or does a bias mean, okay, let's put that bias aside?
I think, legally speaking, looking at the case law, if you have a bias, however that's defined, we'll get to, but if you have a bias, you can't serve on a jury. The question is, as you say, how do you define a bias? And it's a difficult thing to define, but I think having a bias in the context of a trial is someone that could not fairly look at the evidence, someone that could not follow the judge's instructions, and someone that could not return a certain verdict that was supported by the evidence, whatever that verdict may be.
So when the judge says, all right, you have to be able to put that out of your mind and look only at the evidence. Well, first of all, I'm not sure that's true. I think that the person can bring his or her life experience. But nonetheless, she says, I think I can. And then the judge says, I have to be assured. Again, parenthetically, I don't think that's the case law, that you have to be assured. But what her last answer is, I think so. I think I can do it. And then the judge, if he wants to be careful, says, well, you're conscious for any reason you can't. We don't have that question. So it goes back to Justice Budd's question. I mean, this isn't a bias until it impacts your ability to be fair and impartial, right?
Correct. And I think that Justice Lowy, what you're getting at, I think, is it plays out in the judge's findings in a way in that he makes this finding that he actually says that she said she would have trouble with it. Nowhere in her responses does she make that statement that she's going to have trouble with it. As Justice Lowy points out, she says quite, I would say unequivocally, in response to the question, do you think that belief would interfere with your ability to be fair and impartial? She said, I don't think so.
I
And
think I can, yeah, she says, I think I can put it aside. But once again, I'm not sure you have to put it aside. Your position is that you don't, right?
no, that you do not need to put it aside.
But you can't be biased as you judge the facts from the evidence.
Exactly.
So what is the guidance you say we should give to trial court judges? We have the liberty of having read the briefs, having considered it. Trial court judge is speaking to 50 or 70 jurors and trying to choose a jury. What guidance do we give when they're doing this individual questioning?
Well, I think the first point of guidance would simply be that this specific viewpoint, which is, as you point out, shared by a large swath of the community, this specific viewpoint is not inherently a bias. What you need to do is, as you do with all jurors that come up who suggest, who respond to that initial question of, you might have a potential bias. You have to probe further. You have to get to the meat of it. Is this potential bias an actual bias? Is it going to affect the juror's ability to be fair and impartial in the case?
So you got a med-mal case, and the nurse comes up and is asked a question about whether there's too much medical malpractice litigation, and does it have an impact, pernicious impact? And the juror says, yeah, absolutely, I feel that. Potential jury, absolutely, I feel that way. The judge's response is not, well, go back to the jury room. You got to ask another question.
Exactly.
And that's your point, isn't it?
Yes.
But how do we, and let's expand on what the chief asked you, and maybe you can finish your answer. And I think it's what I asked you as the first question. We can say, and you want us to say, in this case, if a juror has this particular opinion about the system being unfair and the statistics that have been cited to us and the like, what guidance do we give to trial judges who have either this opinion or other similar opinions, and you conceded that the system's unfair against sexual assault complainants? How do we write that rule that tells judges when it's okay to have a belief system that should be respected and is part of our jury system versus a belief system that is disqualifying? How do we write that?
I think you write that by saying a belief system is disqualifying if it would inhibit the juror's ability to listen to all the evidence, to follow the instructions in the case, and to render a verdict that...
That's the problem, though. So if a juror says, I think that all blacks commit crimes, I think all Italians commit crimes, and then the judge says, well, could you listen to the facts in this case and decide it based on the evidence? Sure. Does that juror sit?
No.
Okay. So then just saying I can listen to the evidence and decide this case, there has to be some opinions that are disqualifying. And when we write this case, assuming that we agree with you, and that's an assumption, what do we say to the trial judges who are watching this case and saying, I have to cycle through 60 jurors at a time, I'm doing this in a minute or less, how do I make these decisions? What guidance do we give?
I think that, well, it's difficult, but I mean, the viewpoint that all blacks commit crimes, I think any reasonable jurist, I mean, any reasonable citizen would know that that's a bias right off the bat. You don't have to dig any further.
So you don't ask that next question.
I don't think you need to ask another question.
What if the juror says, I'm a statistician and I've noted that our prisons have a disproportionate amount of African Americans and Latinos? Also true. Does that disqualify them from sitting where the defendant is Latino or black?
No. No, that's not the same.
All sex offenders can't be cured based upon what I've read and seen in a sex offender case, which happens all the time, jurors say that. Is that person disqualified?
I don't think that that person's disqualified. I think there needs to be more digging in that instance. But, certainly these are all questions that will likely be,
So
that may be raised in the future.
So are no beliefs disqualifying as long as you probe and say, will you apply the facts and the law impartially in this case?
No, I think there are certainly beliefs that are disqualifying, that, as Judge Gaziano raised, the belief that all black people commit crimes. Even if that person can go on, and it's almost, it's contradictory for them to then say, oh, well, I can follow the law. I can.
Right, just
but
like
that-
if,
No, go ahead.
just like if the prospective juror says, well, I think all police officers lie. Well, you don't need a second question.
Yes. You don't.
Not only do you not need a second question, you can't really ask a second question and
Because
have a fair and impartial juror.
Exactly, because that juror inherently would not be able to listen to the evidence in the case.
Before you sit down, maybe there are other questions. Let's assume, for the sake of argument, that you're right and that the judge abused his discretion in failing to, in excusing this juror. Your argument is, well, that effectively gave the Commonwealth a second peremptory. What do we do with the fact that the Commonwealth was entitled to 2 peremptories and used only 1? So even if the consequence was that they were spared the use of a peremptory, they had 1 in reserve.
I've thought about that and thought about that argument further that I raised in my brief, especially in the light of the fact that the prosecutor did not use both of her challenges. And I think that it's not the strongest argument for prejudice. And I would just want to use this opportunity. I really think where the prejudice lies, the first place we have to look at is Commonwealth v. Soares. And Soares establishes that an error that infects the likelihood that the chosen jury will not represent, any error that limits sort of the likelihood that the chosen jury will represent a fair cross-section of the community is an error that goes directly to the juror's right to a fair and impartial jury.
So could the prosecution have exercised a peremptory here? Couldn't they have?
Could have.
So, but then we'd have the same jury.
Yes, and again, that's why I say, looking at that argument, again, I don't think it's the strongest argument for prejudice. I think that what we have here is an error in the jury selection that is going to limit the likelihood that the jury is going to represent a fair cross-section of the
Saying
community.
it's a structural error, in other words.
I don't think it's necessarily structural error, but I think it's an error that's very akin to the error that's at issue in source cases.
But I don't get it, though. I just want to make sure I understand that, because if it was proper for the prosecution to exercise a peremptory here on this same juror, I take it you're saying it was. If it's proper, then the jury we got is the exact same jury we would have reached here.
Yes, and I think, I did the whole jury selection. How would it have been different yesterday? And yeah, it's going to be the exact same jury. That's why I don't think it's the strongest argument for prejudice.
So
Is there a right?
I'm not sure what you mean by that. Are you
It's
saying
not-
it's
I
not the
wanna-
strongest
I
argument for
wanna-
prejudice, therefore there is no prejudice? I should prevail on the
No,
legal issue,
no,
but I recognize that my client's conviction will be affirmed. Or
No,
are you
I
saying, no,
think
you
that-
think he should get a new trial?
Essentially, the argument I raised in my brief, I want to waive that argument. The prejudice argument I raised in my brief, I do not think is, as Justice Kafka points out, the jury's going to remain, it's likely
So-
to remain the exact same.
So are you saying the issue is not whether we affirm the conviction? We should. The issue is only whether or not we provide guidance to judges with regard to their exercise of cause challenges.
No, I think that what I'm essentially doing is raising a separate, a new prejudice argument. And I think that, again, what I'm saying is that this is similar to a source. So source is
so you're-
based on,
Doesn't SOARS deal with peremptories?
yes.
All right, so if you're saying you're just conceding that the peremptory would have been appropriate here as opposed to having been challenged for pattern, and thereafter the inquiry could go on, are you saying that prejudice is, are you saying the peremptory is just automatically okay? Because in SOARS it was challenged.
Yes,
And this would was there grounds to challenge it here?
Well, we have no way of knowing that. We don't know what the race of the juror was.
I know that, but, you know, you're making the Soares argument.
Well, making the Soares argument in the context that Soares was basically the reason that they presumed prejudice in Soares was because the use of race-based peremptory challenges was likely to limit is going to limit the likelihood that the jury would represent a fair cross-section of the community. That's the basis of Soares. That's the rationale behind Soares. That's why prejudice is presumed in Soares. It's because the use of a race-based peremptory is going to.
And of course, Soares wasn't raised below.
No, I don't think Soares was raceable. I mean, we don't know that because we don't know the race of the juror.
No, but the trial lawyer said nothing about Soares.
Yeah, trial judge.
But you're saying whenever a judge makes this type of error, it should be a new trial?
I think so. I think that
Prejudice should be presumed, again, like in Soares?
yes, because it's an error you have so many people that have this viewpoint, and most black people have this viewpoint.
What
So
if it's accurate? What if it's an accurate viewpoint?
and if it's an accurate viewpoint, it's even more troubling in the sense that, this error is going to basically.
What if it were the opposite then? What if it were, I believe the system is rigged, the system is rigged against white people? What if the jurors said that? Could you not exercise a peremptory challenge against that person if you're defending a black defendant?
So it's a white juror saying that the system is rigged against white people.
Right.
I don't think that.
I'm just trying to understand, is the truth of I mean, are we going to get into truths of beliefs on all these things? And I mean, that's what peremptories are more, I mean, Soares this is more complicated because there is the peremptory option here. But if you're saying that exercise of a peremptory, I don't know, I think you're saying it's a structural error. If a judge does this, it's evidence of racial bias, I guess, on the part of the judge. Is that what you're saying?
No,
Okay, I'm just confused with what you're saying.
What I'm getting at is that, and this is, I believe, the rationale behind Soares. Soares is, it doesn't say that, the rationale behind Soares is that using race-based peremptory challenges is going to limit, it's going to prevent the jury, the chosen jury, from representing a fair cross-section of the community. That in itself is infringing on the defendant's right to a fair and impartial jury. So any limitation on the likelihood that the chosen jury will represent a fair cross-section of the community infringes on the jury's right, the defendant's right to a fair and impartial jury. I think what we have here is it creates the same exact problem. Dismissing people for cause who have this viewpoint, it's inherently going to limit the likelihood that the defendant is subject to a jury that is made up of a fair cross-section of the
What about
community.
the other way? What if it's a child rape case and the prospective juror says, well, I work in this, I'm a SANE nurse, whatever it is, and I think that most children who report sexual assault are telling the truth, even though they don't necessarily disclose right away, and that's their belief system. Is there a second question about whether or not that belief system can be put aside, or are they automatically excused?
I think there has to be some further probing in that instance as to whether they can still be fair and impartial despite holding that viewpoint, whether they can take the evidence in this particular case and listen to the victim in this case without that belief influencing their decision.
And does the judge need to make a credibility finding that when they knock this person off, that they don't believe they can be impartial? Because this judge doesn't really explain why he's knocked the person off, right? It could be because the person has this belief system or it could be because the judge doesn't believe that the person's saying is being truthful when she says she can't or be impartial, right? I mean, she can be impartial, right? We haven't resolved that ambiguity here, have we?
I don't think he's making a credibility finding. I think certainly there are instances in which there would have to be credibility findings made. In this instance, I don't think we
But I think you're saying in certain cases, you've got to ask those questions and you've got to make that credibility determination, don't you? Isn't that what you're saying? When some of these belief systems, particularly ones that don't have much factual basis, because we've got a lot of belief systems without factual basis out there, right?
Yeah. Yeah, and I think what the judge needs to do in that instance, we're talking about something that is not supported by any factual basis. The judge needs to just probe and see if that's going to affect their ability to be fair and impartial. And of course, I think the judge can make a credibility finding as well. So if the juror says, "Oh no, it's not going to affect my ability to be fair and impartial," the judge can say, "I don't find this person credible." And I see I'm way over time, so I would just ask this court if I could file a 16L letter just with respect to the prejudice issue, because I do think that it's worthy of a little further discussion.
All right, we'll give you that chance, and we'll give Ms. McKenna a chance to respond.
Thank you.
Ms. McKenna, you've been very patient.
There's no choice.
Well, thank you very much. Gail McKenna, Assistant District Attorney for the Commonwealth, if it please the court. Today, we're here talking about an essential component of our criminal justice system, which is that every litigant that comes before the court has the right to a fair, impartial, unbiased jury guaranteed under the Sixth Amendment and on Article 12. I think, as we all know, in ruling on challenges for cause, the trial judge is the gatekeeper. And what the trial judge does, as he did here, was he looked at the potential juror. He asked the juror questions, and he made a credibility determination that does not get de novo review here at this court, but gets substantial deference by this court. And in this case, a juror self-selected, self-reported that she had a particular bias.
Isn't his error of law to insist upon a blank slate? Because we have Mutina, we have all the cases that say jurors don't come to us as pieces of clay for us to mold. They all have opinions. And this judge ultimately was pushing her to say, I will just put aside what I believe, and that's not appropriate. So that's the error of law here, isn't it?
I don't think that's what the record reflects, Judge Gaziano. I think that what the judge was probing here was to see if the belief system would interfere with the obligation that every juror has to be fair and impartial and to treat each litigant who comes before the court as an individual.
But let's look at the,
I was just going to read the actual interchange here because I think it'd be useful. She says, I think the system is rigged against young African-American males. I'm happy to serve on the jury trial on the jury because I think it's important, but then the judge says, you think that the belief might interfere with your ability to be fair and impartial? And she says, I don't think so. And the judge says, you think you can put aside that opinion and bias? She said, I don't think I can put it aside. I think that's, and he says, no. And she said, I think that's the lens that I view the world through, but I think I can be unbiased. I think I can listen to the evidence. And he says, all right, but you're going to have to be able to put that out of your mind and look at only the evidence. Do you think you can do that? I think so.
And he didn't believe her. And that's his province. And that's what we ask our trial judges to do as gatekeepers here.
But is it an appropriate question to tell her that she has to put it out of her mind and she has to put that aside, as opposed to her view that it's the lens through which she views the world, as the way all jurors come to the court with with life experiences?
Your Honor,
with children or not with children, with, I mean, everything. Nobody's a blank slate, right? So the question is whether this is a belief that is just part of the lens through which she views the world. She can't put it aside, but she can certainly say, notwithstanding that, I can try to just look at the evidence here and decide the case on the evidence.
right, and she did say that, and the judge didn't believe her.
So you think it's a matter of credibility?
I do, completely a matter of credibility.
But he's not clear on that, is he? We can't tell whether he's kicking the juror off because she retains this lens through which she views the world, or because he doesn't believe, you're jumping to the conclusion that he doesn't believe she can be put that aside, that she can be impartial, that she can't be impartial and she can't just do this on the evidence? He doesn't make that finding, right? I mean, I know it's awkward and uncomfortable to have a judge be forced to do that, but the
But what he
judge,
does is he rules on the objection. And I think that that's quite telling, because next what happens is the objection. And I think that we have to read all of this start to finish. We can't just jump in and read one part of it and then figure out what was going on. But then there's the objection, which is the defense counsel brought up issues involving mass incarceration, which frankly wasn't one of the things that the juror specifically mentioned, that she did say that she could be impartial and that he's not a juvenile. And that's when the judge made his findings, such as they are, which I would say were credibility-based.
Well, why don't we read them? He says, yeah, but he's a youthful-looking guy, and she says she's going to have trouble. She hesitated quite a bit, counsel, and I find on the record that she really struggled with it. She said, I'll try to, and then that, and I'm going to let her go for cause. That's what he said.
Right, but before that, the defendant had made his, that was what the specific objection that the defendant made was, and the judge responded to that, as well as, in light of the entire colloquy that he had had with the juror. And remember, we're not scripting what a judge says to a juror, nor do we want to. I think we want it to be sort of an organic process where a judge is asking questions, sizing up a juror, looking at them, getting tone of voice, demeanor, all of those things that are sort of the nebulous things that go into assessing credibility. And here, where he's talking about her hesitating, that she's going to have trouble, that she said, I'll try to, that he just didn't believe that she could be fair and impartial.
But see, I agree with the first part of what you said. I mean, it's really important for the judge sometimes to even ask questions that might seem unnecessary, to have the potential juror talk. And jury impanelment's hard to do.
Absolutely.
For judges. Really, it's exhausting, takes a long time. We've got attorney voir dire in Superior Court, and the judge has to go through lots and lots of jurors, so we have to recognize that.
Right.
But I'm still focused on whether or not, is this an error of law? Because the specific issue is he's saying he has to be assured that she can put her belief system out of her mind. And then she says, I'll try to do it. Should she be asked to put her belief system out of her mind? Or when she does say that she thinks she can be fair and impartial, and she'll try to put her belief system out of her mind, that we don't really have a credibility determination. We need a record that needs to be developed a little bit more.
I would disagree, Your Honor, because that was also in the context of you're going to have to put that out of your mind and look only at the evidence, which is him saying to her, you have to make an individual determination, which is what a juror has to do. You have to look at the evidence and treat the person as an individual. And we have ancient law that goes back and says that none should sit who are not entirely impartial. The conundrum here is that had the judge allowed this juror to sit, I can see that the defendant would call this an error, that this person was able to sit because they weren't squarely impartial. Just because the belief system seems to go in the direction that would be favorable to a defendant doesn't allow them to sit as a juror. They must be fair and impartial.
So maybe you can help me, because when I read this, and no matter how many times I read it, I'm left with this is the impression I'm left with. Gee, I don't know. I don't know yet. I'm not sure yet.
Then I think that what we do is we go to the standards under our law, which is the judge is the gatekeeper. The judge is making the determinations here. This isn't de novo review, and we look at the LL standard that says among the various options, it's the trial judge. And just because we might feel differently, any one of us, doesn't mean that we get to substitute our judgment for that of the trial judge. So that's just quintessential, the standards of review of this court that are well established, and they work well here. I would also say that given our long jurisprudence, which our Declaration of Rights, which, as we know, our Constitution is older than that of the United States. If there's a question, we shouldn't be talking people into being jurors who we suspect might be partial in any way. And we know there's an old case out there, Commonwealth versus Auguste.
Isn't it the opposite, where he talks her into not being a juror? I think part of the reason is he gets an answer, she says, I think so, and then he keeps going. I mean, you read this, and at one point she says, this is my belief system, I'll be fair. You think so? Yes. And then it continues. You can read the transcript and just say, stop. You got
Why?
your answer.
But then I would have to ask, why should a judge ever stop until a judge is satisfied with all of those answers?
Well, do we ever factor in differences in language and the way women phrase things versus the way men phrase things? And is this a female juror? I don't remember.
It is a female juror.
It was liable, much more likely than a male juror to say, I think I can, and that it means just as confidently, yes, I can.
Well,
But it's just qualified language.
And there's actually case law that talks about not looking at the specific language, that the words "I think I can" actually mean, yes, of course I can. We have established case law that says that. That's why we have to rely on our gatekeeper, the boots on the ground here, to get that overall sense of hesitation. And I don't know what we do. I don't know what we do anywhere about implicit bias.
What do we do about, I just can't remember right now, instances in jury selection where the question is, would you believe a police officer over other witnesses? And the answer is yes.
I think the question is always to go further, to ask more questions. But at the end of the day, I don't think we're seating those people that say that they believe one person over the other. As I said, my own instinct is always that if there's a question about bias or lack of ability to be impartial, there's no reason to seat that juror. There's no reason to seat a juror who's questionable in any sense. This juror is questionable, again, no de novo review, credibility determination by the judge who's our gatekeeper. And if there's a question here about partiality, then the defendant is going to raise that either way, because it doesn't really matter what the underlying issues are. The question is partiality.
Isn't the fear, if you do that, don't you then have to worry about keeping off a cross-section of people who may believe that the system isn't fair for Black people? If you say that they're not qualified because they have this belief system, then it doesn't...
Well, let's be very clear. I did not say that, nor do I believe that. The question is whether the particular belief system, which could be the rich pay too much taxes, poor people aren't treated correctly in our system. Any of these belief systems.
You have to probe. You have to go further.
You have to probe. You have to go further.
But doesn't it depend on the question that's asked? Because it seems like he was talking about bias and she was talking about her belief system.
But she came up and she volunteered in response to the question about, do you have a bias?
No, is there anything that would interfere with your ability to be fair and impartial was the question.
Okay,
Answer
I'm
yes,
sorry.
and then the clerk and judge said, let's ask about your bias.
That's right.
Okay. I knew, but I think that what we do again is we look at the entire colloquy. And I think one of the cases that's actually quite helpful is one that was cited in the amicus brief, which one of the amicus briefs, I'm just going to pull that out right here, is Mason versus United States. And it was a case by the Circuit Court of D.C., which is essentially their SJC. And it was a very similar situation, except that in that case, what the judge did is that the judge found the belief system itself was what was disqualifying to the juror. But what the court went on and said was, it's possible that the beliefs themselves are not disqualifying. You have to go further and find that they were unable to be impartial. And what had happened in this case was that once the juror said, the problem for me is the court ruled, the problem for me is she said she thought people were being treated unfairly here in DC, not just in Texas, so it has to be systemic. She believes that black men are all being treated unfairly, I'm paraphrasing. So when presented with any belief system, except one that is perhaps so toxic, all Italian men are criminals, that we do require and we do want further probing. And then what we do is we rely on the judge, who's our gatekeeper, to do the credibility determinations.
But again, the questions that were asked, it seems like they were talking past each other. So he was asking about bias, she was talking about her belief system, and he asked her to put aside her belief system. And it's sort of like he conflated the two.
But she had to put aside her belief system in order to treat this person as an individual. I think that all of us can agree that there is a history in the country of black youth, black people, not being treated equally and fairly. But if I'm going to sit on a jury, no matter who that person is, I have to put that aside and treat that person as an individual, all at the same time that I know that and believe that, because I have an obligation to treat that person as an individual.
So you can't bring your life experiences to your work as a juror?
I think that it's a different thing to say that I think that I can bring my life experiences, but I think that first and foremost, I have to be able to follow the judge's instructions. I have to be able to treat that person as an individual, hear all the evidence, and I can't let that belief system, no matter how well-founded, interfere with any of that.
But
Oh,
didn't
it's
So
she
if
say
she had asked
she
him
could?
that, if she had asked the juror all those questions, then he would have had that information to make a determination as to whether or not.
But again, Judge Budd, what we're doing here is that if we don't want to make judges read scripts, and I don't think that we should, we're leaving it to a judge's discretion to ask particular questions. At times, those questions will be inartful, but what we want is we want a judge to size somebody up. We want them to make a credibility determination. We want them to look at a person in the eyes and figure out so many intangibles about credibility, demeanor, tone of voice. He made findings about some of them. And the fact is, he just didn't believe her that she could be an impartial juror. And as I said, when we're dealing with juror partiality or impartiality, it is so important that if a judge has any questions about that, that person shouldn't sit and we should have someone else come sit.
Can I,
Sure, Judge Lowy.
so those are all great points, and also we can't expect judges to bat 1,000% when they're going through 90 jurors and just have perfect language all the time. But as it relates to the big picture here, why can't a juror look at the facts and bring his or her life experience? They say they can treat this defendant fairly, treat the government fairly, but there's evidence of flight. And
I'm sorry?
Evidence of flight, consciousness of guilt.
Sure.
And the judge gives a consciousness of guilt instruction, and there's an issue of how much weight the jury gives the flight after the consciousness of guilt instruction. Why isn't it perfectly appropriate for that juror who might have certain views about the way black people are treated to factor that life experience into their determination of how much weight to give the consciousness of guilt evidence?
Was that part of the evidence, and was that
Yeah.
raised in the case? That
Right.
because he was an African-American, that he would have had more of an incentive or a different incentive to flee versus someone else?
That's what the juror is bringing his or her life experience and
Was
maybe
that,
believing.
but my question
Yeah,
would have
so-
to be, was that part of the evidence? And we will have trials where that kind of issue will be raised and it will be part of the evidence, and that we will want jurors to look at the evidence, follow the instructions, and deal with that fairly. But we can't have a system where people's idiosyncratic beliefs, opinions, which is sometimes based on stereotypes, a part of the jury deliberation process. And that's what we're asking judges to do when they act as gatekeepers. And again, I think the process really has to be organic. We have to have a process where, a judge is sort of responding to what he's seeing, what he's hearing. This isn't an easy thing for a judge to do. I think the easier thing for a judge to do is just let everyone pass by, because then the jury is seated more quickly. But, my own feeling would be, when in doubt, please don't put that person on, because the constitutional guarantee of an impartial jury is much more important than having an iffy person on there. And in this particular case, I think the judge's findings, again, without de novo review and under the LL standard, are perfectly fine to inform the court of what his thinking was about the credibility of this particular juror. So I've gone way over my time. I apologize.
But the hardest,
Sure.
you didn't brief the second question, which is very difficult. If we don't agree with you on the first issue, how do we resolve this? Say we decide this was error. How do we analyze this? Because that, in certain ways, is the most difficult question presented here.
That is a very...
We don't have anything from you on that.
I guess
So
I
you're
was so
lucky you've
convinced
got
of
a
the...
16L letter coming, because it would be helpful to know what we turn to. He relies on, in his original brief, the Mason case, or the DC case, which reverses it. But here, I don't understand how the interplay between peremptories and this plays out.
Well, I think that the court has approached this in different ways. And I think that when a defendant has made claims like this, and what has happened is, in the defendant's claim here was that the prosecutor got an extra peremptory. We know that didn't happen. So based on the claim that's made before the court, there's no prejudice because the extra peremptory didn't happen. But I think it's really a harder issue, because we really have to look at whether or not the defendant was deprived of a partial juror. Would that juror, and then it becomes speculative after that.
But no, I think if you lose, just say, and I'm not saying you're going
No,
to
no,
lose,
no,
but
I understand.
If you lose, the defendant was deprived of an impartial juror.
For a moment before a peremptory was exercised.
But even more complicated, deprived of an impartial juror whose beliefs are shared by a large cross-section of our society. That's the Mason case, right?
That's the Mason case.
And also there's a decision out of the Third Circuit by Higginbotham, which makes a similar point.
I'm not familiar with that case.
But I guess, how do we deal with that? And how do we analyze that if it's an error? And are there cases that you can point us to? Because again, we have nothing briefed on that from you, which is difficult, because that's hard.
I think the problem is that what happened in the Mason case is that the judge removed the person based on the belief system, not what happened here, and that was reversible error. But what we've done here in the Commonwealth is that we've looked to see...
Again, that's assuming the outcome.
No,
Say
but
you lose, and we decide it was because he knocked the person off because of the belief system. Again, I'm not saying that's what's going to happen, but we don't have briefing from you on that issue. And what cases should we look at? Because right now, the only cases are the ones he's presented.
What we have done in the Commonwealth, which my brother did also brief, is that we've looked to see what has happened as far as what's left for peremptory challenges. And in this case, the prosecutor still had a peremptory challenge left, so the prosecutor wasn't given an extra peremptory challenge, and that's the argument he makes. And so she still had one on the table. Say again?
Is the assumption the prosecutor would use the challenge? Or we don't know?
We don't know. We just don't know. So unless,
Okay, so, what we'll do with regard to that issue, defendant has 7 days to brief that particular issue of prejudice, no more than 10 pages double-spaced. And you don't need to use all 10 if you don't need it, and we'll give you the same opportunity in 14 days. So you'll have 7, you'll be able to see what he writes and have 7 more days to address the issue of prejudice.
Thank you very much,
And that-
Mr.
and
Chief
that-
Justice.
And no inference should be made as to whether we will reach that issue, but if we do reach that issue, we want to make sure we have adequate briefing on the issue.
Well, I would respectfully otherwise rest my brief, and thank you all for your kind attention today.
Great, thank you.
Thank you.
Court, all rise. Hear ye, hear ye, hear ye. All persons having anything further to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting in Worcester, the defendant for the Commonwealth, at present depart. The sitting of this court is now adjourned. God save the Commonwealth of Massachusetts. Please remain standing while the Justices exit the court.